draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3051 et al., United States of America versus Antonio Moreno-Membache, appellants. Ms. Hernandez for the appellant, Mr. Pierce for the appellee.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. May it please the court, Carmen Hernandez, arguing on behalf of Mr. Antonio Moreno-Membache. Your Honor, as the court is well aware, more than 97% of cases are resolved by plea agreement. And plea agreements have a constitutional component because a defendant waives multiple rights, constitutional rights to a trial, to confront witnesses, to have the government prove its case when he signs a plea agreement. In this case, the issue of the defendant's eligibility for the safety valve was a major issue in allowing Mr. Moreno-Membache to plead guilty. In fact, the government had wired the pleas. That is, the government had required that all three defendants plead at the same time, or they would have had to go to trial. Mr. Moreno-Membache reluctantly agreed to plead guilty. The original plea agreement was aborted because he refused to plead guilty unless he could argue that he was eligible for the safety valve. A provision in the plea agreement states that the government would not seek any enhancements under Chapter 3 of the sentencing guidelines. In order to be eligible for the safety valve, a defendant cannot have an aggravating role in the offense. Chapter 3 is the section of the sentencing guidelines that includes aggravating roles. Now, the government seems to argue that they weren't below, that they did not argue, that they did not seek an enhancement under Chapter 3, that they merely were arguing that they had role enhancements. But that misconstrues the application of the sentencing guidelines, which in order to be prohibited from eligibility from the safety valve, there has to be an enhancement under the role adjustment. It's not enough that someone be a lead or a supervisor. If he doesn't get a Chapter 3B enhancement, he is eligible for the safety valve. It was clear everyone understood that this is what the plea agreement meant and intended. It's clear that it's a reasonable interpretation of the plea agreement. The government's argument on the plea agreement would invalidate or would give no meaning to the sentence in the plea agreement that said that the government would not seek an enhancement under Chapter 3. The argument that the later sentence that says the government could object to application of the safety valve somehow nullifies that earlier sentence makes no sense, because you can challenge eligibility for the safety valve under the 4 other provisions of the safety valve. In order to be eligible for the safety valve, you have 5 requirements. One of them is aggravating role. So the government was free to argue against the safety valve, but not free to argue on the particular provision that said a role enhancement. The
guideline sentence was well above the mandatory minimum. I think it was 262 to 327 months.
That was not Mr. Moreno-Membache's contention. That's not what he argued below in the.
Let me just spell this out and you can respond.
Yes, sir.
So had the government sought a 3B enhancement, the range would have gone, maybe I have the numbers wrong, but the range would have gone from something well over the 120-month mandatory minimum to would have been increased even more. And it could have gone up if they had gotten a +4 enhancement, it could have gone up all the way to life. So when the government made the commitment not to seek an upward 3B enhancement, that commitment still seems to be doing a lot of work, even if the government is reserving all of its rights to argue that the sentence should not drop below the mandatory minimum based on the safety valve, based on any ground under the safety valve.
Your Honor, that's not how you would interpret the plea agreement. The plea agreement was a C plea. That means the court had to impose the agreed upon sentence to 120 months. So nothing the government argued at sentencing could increase the sentence above 10 years. It was a plea pursuant to 11C1C, Rule 11C1C of the Federal Rules of Criminal Procedure. So the only meaning that could be, the only significance of agreeing not to seek a role enhancement under Chapter 3 was if they were eligible for safety valve. If they were not eligible for safety valve, there could be 17 enhancements and it would not increase the sentence above 120 months. So that provision had meaning only in the context of safety valve.
I understand that, but another way of thinking about the overall structure of this plea agreement is that the government was giving up all of the enhancements. I mean, the only fight in this case was either 120 months or less under safety valve.
Correct, but it wasn't given. But there are 5 provisions under the safety valve: one criminal history, no gun, role enhancement, and had to be honest in a debrief. So there's, and it was 120 months.
But the government reserved the argument that the defendants don't meet the criteria for safety valve relief. And on its face, that the criteria, not some of the criteria, the criteria.
Well, correct, but the only way to give meaning to both provisions, that is to the provision that they waive Chapter 3 enhancements and to the provision that they can argue that they don't meet the criteria, is to say, okay, so you're agreeing that as to one of the criteria under the safety valve, we're not challenging that. So that gives meaning to the government's view, to the sentence that protects what the government wants, and it gives meaning to the sentence that protects what the defendant wants. There is to say.
Just to be clear, we held that they were eligible for safety valve consideration in the prior case, but just I want to make sure I clarify. I understand exactly your response to one of Judge Katsas's questions, and that is, once we got back, if you got through the entitlement to say you got through all the prongs on entitlement to safety valve, and so now you're going to argue it should be less, and the district court's going to look at the sentencing guidelines range. But your understanding of this plea agreement was, even if we were in that situation where we're now in full safety valve land and we're arguing about whether we should go down, that the government was never going to pull out of its pocket this enhancement and say it should be more. It was that the sentence was absolutely capped at 120 months.
The sentence was absolutely capped. The government never argued otherwise. And
so there was no use for this. And I think they said in their brief, they admitted in their brief that there was no use for this line about the government agrees not to seek any of the adjustments because it was a C plea.
Right.
Their brief argued that there was no point to the sentence under a C plea.
Correct. It only had meaning in the context of safety valve. And to say we're not going to do this for safety valve, but we're going to do that, it would be an illusory promise. What exactly would they have given? And it certainly was not what the defendant understood. And and the defendant's understanding is a reasonable understanding of these provisions. And therefore, to believe otherwise or to rule otherwise, it just goes against contract law. Now, I haven't even started my second argument. You
can go ahead. You can take a few minutes on that. Go ahead.
Thank you, Your Honor. Yeah. So, as the court knows, there are few safeguards at sentencing for a defendant. While there have been cases that this court has decided that maybe you need a burden above preponderance, it seems pretty clear that most courts do not require more than preponderance. But here you have out-of-court declarants, not confronted, criminals who have a lot to gain by reducing their sentence. They give the two.
Mr. Hernandez, could you? I don't want to interrupt you, but I do, I guess.
Yes, sir.
Could you make your argument in terms of not just that you think the district court's findings were wrong, but that they're clearly erroneous?
They were clearly.
That's what you have.
Yes, sir.
Tell us why they were clearly erroneous.
Well, for two reasons. One, the way the hearing went forward is they allowed an agent who wasn't the case agent to summarize the testimony, ignoring all the contradictory statements. So that brought defect into the whole hearing. But more specifically, and there's a chart in my summary which shows it. So the government argues, and the court found that my client was the logistics manager in charge of hiring the crews and paying the boat crews. We have 5 cooperators. They were all each crew members. 3 of them were crew members on the Mitsby, which is the case that we're involved in. And the other 2 were crew members on 2 other boats. And yet none of these 5 people had been hired or paid by my client. On issue after issue where the court found my client did this, in fact, these 5 cooperators, the undisputed facts contradicted what they claimed. And this court has not given a lot of procedural safeguards to findings by the district court, but when there are these internal inconsistencies between the allegations and the facts, this court has said, you cannot do this. You must go back and resolve these inconsistencies. And as I say, there is a listing of all the things. They say he was in charge of the launch. He wasn't even present. At least one of the cooperators says he wasn't at the launch. One of the cooperators says he was. So that's an internal inconsistency. They say he was he played the role of being in between the owners of the drugs and the people on the boat. Yet there's not a single phone call between the owners of the boats, my client, and then that he then sends that information. And there's 100,000 phone calls in this case, 100,000, and they can't come up with one. There's so many inconsistencies in this case, Your Honor. They're all set out in the.
Can I ask you about the gun possession?
So the gun.
Okay, so you have, and again, unfortunately, you're up against a very onerous sort of standard of review. So tell me your best argument as to why it was clear error for the district court to credit the 2 witnesses that talked about one saw a gun and one saw a silhouette of a gun.
So yeah, silhouette is the agent's word, but in any event, there are both of these cooperators are interviewed approximately 7 or 8 times, each of them on separate occasions, starting days after they get arrested in 2012. It is not until 2016 that they first mention a gun. And they're inconsistent because Paredes, the captain, not only doesn't mention a gun until 2016, I believe that's his 7th interview, but then he says he saw this gun at a meeting. Now, for four interviews, he never even mentions my client being present at a meeting. And then all of a sudden it's at a meeting. Purportedly.
Did he talk about meetings in those prior 4 interviews?
Yes. From the start, he talks about meetings. They describe, and both of them, all of them, they describe the location of the meetings. The meetings are held at the home of the owner of the drugs. They place all of the defendants, all of the named defendants at these meetings, but not my client. And then all of a sudden.
Had they been asked about a gun earlier as well, or was that not asked until a later date?
Well, Your Honor, these proffer sessions are agents and the the defendant and the defendant's lawyer. What's asked, we don't know, because all we get is a summary on a 302.
Okay.
But if there's a gun, you would expect that would have been brought up early on.
Mhm.
And as I say, there are all these things. Not only does he not mention them, but there are inconsistencies where in one place they will say, my client was a minor person, or the other brother was the one who gave instructions, and all of a sudden they reverse course altogether. And then
you were able to argue all these points about the belatedness of this information to the district court. If you had a jury trial and argued these same issues to a jury, and the jury had found that there was a gun, I think you would agree we would not be able to overturn it on this record?
Correct, but so I didn't have the opportunity to confront these witnesses. What happened in this hearing, and this is why the manner in which the information was introduced affected the whole hearing. There are 8 interviews, say, for one defendant, for one cooperator. He gives contradictory statements, and at no time is he confronted with his contradictory statements during the proffers, and at no time when the law enforcement agent testifies at the evidentiary hearing does he say, oh, he told us X, then he told us not X, then he told us Y. No, what the law enforcement officer did is he selected the one bit of information he wanted without acknowledging it. And because
But you were able to ask Mr. Suchet questions about the information in the record that supports your client, correct?
Right, and then the court ignores a lot of that. Even the court, like at one point.
I'm just saying, if a jury had come to the same conclusion with, you asking the questions and in front of, say, the same presentation, we would credit that. Is our standard for clear error and a district court finding of fact more probing than we would of a jury's resolution of a fact question, or is it essentially the same?
Well, I would argue it's more, because at least the judge has to give her reasons why, whereas a jury just makes a finding. Okay. And there's no reason for you to defer to the district court. There's no demeanor judgment in this case. The judge didn't get to see these cooperators, and the judge did not explain why she was accepting this statement in contrast to that statement. The judge, in fact, at times.
I thought she said she was accepting the things that were corroborated.
No, she accepted things that were not corroborated at times.
Well, just as to this gun, there were 2 people.
There were 2 people. Supposedly they were both at the same meetings, but yet one sees it at a meeting, the other one doesn't mention seeing it at the meeting. One says he saw him pull it out, the other one says he just saw it he saw something under. And also, more importantly, even if you accept that, neither of them said that the gun was used in connection with the offense. So neither of them said he used the gun to intimidate the other people. He used the gun to safeguard the drugs. There was the legal finding that it was used in connection with was never addressed, or was not addressed adequately, I would argue, to the court. Thank you, Your Honor. Thank you for letting me go over.
You're breaking up there. Okay, we'll hear from the government.
Good morning. May it please the court, James Pierce of the United States. The district court did not clearly err in finding that defendant Moreno-Membache was not entitled to safety valve relief, both because he was a manager and supervisor and because he possessed a gun. The court below also correctly concluded that the plea agreement did not preclude the government from making the manager-supervisor argument.
So what is that sentence in paragraph 9 of the plea agreement that is the lead-in sentence to what the defendant's allowed to argue? The government agrees not to seek any of the adjustments set out in the USSG Chapter 3, Part B. You said in your brief that was an empty phrase because it was a C plea for 120 months. You were never going to be arguing for adjustments anyhow. So I just want to make sure I understand your position, is that was sort of a throwaway line.
And perhaps we should have been more precise. What we argued is that it was unnecessary, which was the same conclusion. That
it was entirely unnecessary. Okay, so had no reason to seek, is what you say in your brief, and it was unnecessary. So that means, is there a difference between being unnecessary in the plea agreement and a throwaway?
So I think the plea agreement on this point was not.
Is there a difference between being unnecessary and a throwaway line in the plea agreement?
I don't think that it is a throwaway.
Well, if it's not a throwaway, it must be performing some function, but you told us it was unnecessary twice.
So I think it is unnecessary, if I can just place it in the context of the full paragraph in which it appears. So it's a C plea, so the guidelines calculations are unnecessary. However, paragraph 9 begins with the statement that recognizes, although it is a C plea, sentencing law requires that there be a guidelines calculation. So the following three sentences, the first one about criminal history, the next one about Smith departures, which have to do with a removable alien, and the third are all addressing guidelines issues that are, and we would concede, not
Well, to be clear, it says that the pre-sentence report will include a calculation of the advisory guideline range. It's not talking about what the government would be doing in that process.
Well, sentencing law would. I'm sorry, Judge Millett, you just broke up at the end.
I apologize. What the prosecutors would be doing at the sentencing hearing is different from what your first line is about what the pre-sentence report would do. We're talking here about what the government was doing at the sentencing hearing.
Yes, but the point is a sentencing hearing would nonetheless, through a PSR and ultimately at the sentencing hearing, would require a guidelines calculation, even if.
Right. Who does the guidelines calculation in a pre-sentence report? I thought that was the probation office. Is that wrong?
That's correct. The probation office does that independently. Right. It hears from both parties.
Independently. Okay. So when you say the government agrees not to seek any of the adjustments, that's separate from what the probation department could have said whatever it wanted in its pre-sentence report about whether it thought there was a managerial supervisory role. But this was a promise for, when I see the government, I'm assuming that means the prosecution, not to seek any of these adjustments.
Indeed, and when the government made its sentencing submission, it said quite clearly when addressing the pre-sentence report, we agree that there are facts that support the determination that the defendant is a manager and supervisor, but consistent with the plea agreement and specifically paragraph 9, we are not advocating for any such adjustment. The point being that advocacy as to the manager and supervisor applied not for a guidelines purpose, but as the final sentence in paragraph 9 makes clear.
Also, I'm sorry, go ahead. I apologize.
Just to contest the defendant's eligibility for safety valve relief.
Sure. But the difficulty is that to get the safety valve ineligibility on this ground, the prong force ineligibility, they have to qualify as a manager or supervisor, quote, as determined under the sentencing guidelines. And so you'd have to find, and you'd have to advocate to argue ineligibility that under the sentencing guidelines, under USSG Chapter 3, Part B, they are a manager or supervisor. And so you couldn't, consistent with that promise in paragraph 9, argue that they are ineligible under 4. And it gets, I think, harder if we look at 5C1.2, which is a sentencing guideline that governs the safety valve. And it says to fall within that Chapter 4 ineligibility, you must be a defendant who receives an adjustment for an aggravating role under 3B1.1. That's note 5. And so I just don't understand how you can have that promise in the plea and yet still be allowed to argue that under that very sentencing guideline provision flagged in the plea agreement, they are a manager or supervisor, which is what you had to do under the sentencing guidelines. They had to receive that to be ineligible for the safety valve. That's my difficulty.
And again, I'm sorry, Judge Millett, you cut out a couple of times, but I think I get the thrust of your question.
Sorry, am I cutting out for other people?
No, I've had this problem. I think it may be on my end, even though I'm in the government office. So I apologize. Again, I think it is inelegantly drafted, but I do not think
What is
that is an understatement. I mean, excuse me, but we're talking about two sentences. I can't believe that the lawyers who negotiate these things can't come up with clear language that avoids these kinds of disputes. Inelegant is an understatement. In fact, doesn't that, in essence, kind of concede the point? Because under US v. Henry and other cases, if there's ambiguity in this, we construe it in the defendant's favor.
So the next
Isn't that
point I
pretty
would make
obvious
is,
from the half hour we've had here about debating what this means, that whatever this means, it's at least ambiguous, and therefore we should construe it in favor of the defendant?
I do not think here that inelegance raises to the level of ambiguity. I think, as the district court found below, that final sentence makes quite clear that we are talking about two separate analyses. One is enhancements for purposes of the guidelines, and Judge Katsas talked about the potential exposure that a guidelines determination would subject the defendants, here defendant Moreno-Membache, to, and the safety
Wait,
valve.
I'm sorry, can I ask you, follow up on that? I still don't understand that exposure. And in fact, I think your statement that it was an unnecessary sentence in the plea agreement says there is no exposure, because you weren't going to argue it for the pre-sentence report. You didn't. And even if they had been able to argue to the district court, depart, you know, we're all eligible for safety valve, please depart, you wouldn't have been able to argue it there either. So I don't know how, I'm back to, I don't know how you can tell me in your brief it's unnecessary, and then still tell me it was serving this function in calculating the guidelines range.
Again,
sorry, I really am confused.
So the function of the sentence in paragraph 9 was addressing the guideline. Following sentence was recognize that there is, under a C plea, not the need to address these guideline factors, but also it's not necessary to address the criminal history. It's not necessary to address whether the Smith departures, which is that third sentence there.
I'm sorry, no, it didn't say you don't address it. It says it's been factored in.
No, my point is not that the Smith factors haven't been addressed. There would be no reason to have a sentence addressing the Smith factors at all under a C plea, because the guidelines determinations are ultimately unnecessary. But what the plea agreement does there is recognize a handful of things about the guidelines determinations that ultimately are not relevant because this is a C plea.
Well, the criminal history is relevant because they have to be category 1 to have safety valve.
That's true, but the Smith departures is not, and so I think the view there.
Other than it might have been a kind of because that's sort of generally, as I understand it, a downward adjustment in the sense. I mean this in a colloquial sense, not in a formal sentencing guideline sense, but because people, when they are here as immigrants, will be deported at although these folks were brought in, they didn't come in.
Yes.
So I assume that's why that was there, just as an assurance to the district court. And also it might have meant that if they got safety valve and were able to argue to the district court to apart from mandatory minimum, they wouldn't be able to say one reason to do so is the Smith rationale, because that had already been baked in. And it seems to me that there's is it five different factors as to
That's
what
right.
it takes to qualify for safety valve. And so the plea agreement, when it says you could still argue eligibility, certainly left you free to argue all the other grounds, including the firearm ground that you did argue here, right?
It's true. I won't concede that it didn't allow us also the supervisor manager, precisely because the language refers to all of the criteria, does not meet the criteria. That's all 5. It doesn't say excluding the supervisor manager piece of it. Although, Judge Millett, I do think you touched on something important just in what you just mentioned. I recognize that this is not helpful as regarding the other defendant. If this court were persuaded on the plea agreement, that the plea agreement doesn't allow the government to argue supervisor manager at all, that doesn't matter for Mr. Moreno-Membache's case, because the district court did not clearly err in finding that his gun possession was in connection with the offense. We've already mentioned that Luis Paredes, the MISP captain, saw the defendant pull out a 9mm pistol at a MISP planning meeting, examine the magazine, or place it in his.
I'm sorry, Jameen, if you could clarify one thing I was a little confused about. When Mr. Paredes, or Captain Paredes, says he saw the gun pulled out, and it was, I thought the record said it was at a meeting that was somewhere near the MISP launch area, but I wasn't clear whether he had said it was at a MISP meeting. The guy who talked about the silhouette, I think, said it was the MISP meeting or near the MISP, but am I wrong? Is there something in the record? But I wasn't clear where Paredes saw this, where and when he saw this, which meeting?
Certainly. So my understanding of the record, and just one record clarification point, Ms. Hernandez refers to a number of things like the various proffer agreements. The district court commented below that those reports weren't lodged, many of them weren't fully lodged before the district court and a part of the record. And so the record that we're looking at is Suchet's testimony, and that's the record that the district court in its 38-page opinion ultimately relied upon. But to answer your question more directly, Paredes said he saw that at a MISP planning meeting.
Oh, did you? Okay, I did not get that. Do you have a site for that? I just must have missed putting two and two together here. So I spent too much time searching around for that. I know he said at a meeting. He might have said near the launch site, but they may have launched other things from the site. That may not mean a whole lot.
So I have the 214 to 224 of the appendix. I don't have a more specific pin site, which I certainly could get for the court. But my understanding of where the viewing of the gun at the launch site was the other individual, Ivan Campos Riascos, who says that he saw the silhouette of the gun, and that's indeed Suchet's characterization, at the MISP launch site. So one is the MISP planning meeting, that's Paredes. The other is Campos, which says the launch site. And those two facts also address the second piece of the gun analysis, which is its connection to the offense. If you have a gun at the launch site or at the planning meeting of a go-fast vessel, our position would be that is, by its very nature, facilitating the offense. And also, to ensure the transportation of cocaine, and in this case, marijuana, in the MISP's case, from Colombia to Panama. So necessarily that gun is being used to facilitate the drug trafficking offense.
Do you have any further questions, Judge Millett?
When you argue that he was responsible for moving drugs from different sites, pre getting to the boat, was there evidence that in that moving process he was supervising people, or he was just exercising sort of authority over the drugs?
The statements from Paredes and Posmino, who was involved with the March 2012 Go Fast vessel, and Jimmy Gonzalez, who is Moreno-Membache's cousin, indicated that he was not only involved in specifically Posmino and Gonzalez hired.
I'm sorry, you cut out for a second. Could you come back where you? Sorry, he was not only was where I last heard you. Sorry.
I'm so sorry. Yeah. Frustrated by this connection, but that he hired and supervised his two brothers. This is separate from Andres. I believe their names were Faver and maybe Ronario or Romario. These were the ones who moved the drugs from Buenaventura to Choco. Gonzalez specifically said hired and paid, And Posmino, I don't believe he said paid, but certainly said supervised and was responsible for.
Okay.
Of course, the Andres, the other brother, the brother who was apprehended on board the Mississippi, in his first statement to law enforcement, said that Moreno-Membache, the defendant here, had recruited him. Now, of course, Andres later recanted that a couple of months later, a recantation the district court found, quote, simply not credible. And Andres also then went on to say—
Is being the big brother a supervisor?
Is being a big brother a supervisor?
Big brother a supervisor or manager?
I mean, as a big brother myself, I might try to argue that, but that's not the argument on which we're relying.
It sounds like it was all younger brothers here that he was ordering around.
I don't think it was all younger brothers. It does sound as though he had a number of brothers, but it's clear, again, from the phone call as well, there's a phone call between Moreno-Membache, the defendant, and his brother, in which Moreno-Membache says, one of these two brothers who context suggests have been apprehended by police needs to take the fall for this. Right. Again, he's making managerial type decisions about this organization. And when we're here on a clear air standard, that this court does owe deference to the findings of the district court. Not only the findings, but I think it's instructive in viewing the transcript below. The district court was not, Judge Howell was not sort of passively just accepting all of the evidence. She was, in fact, quite active in interjecting and saying, I need more clarity from Suchet. If this is just simply your speculative opinion, I'm not interested in it. If you are telling me what the witness has said, that's fine. And that's reflected again in her 38-page opinion, where she lays out that information which is corroborated by multiple of the cooperators involved here, and then information that she finds either not particularly useful or otherwise uncorroborated. So as to both the manager director and the gun, we think there's no clear error.
Okay, thank you.
Thank you, Your Honor.
Ms. Hernandez, you were out of time, but you can have a minute.
Thank you, Your Honor. I have to correct the record. The government says that the gentleman who claimed that he saw the silhouette said that he saw it at the launch of the Mitsby. That gentleman said that my client was not at the launch of the Mitsby, and his statement as to the silhouette does not refer to the launch of the Mitsby. So if he says, so he explicitly said my client was not at the launch of the Mitsby. These two other people were in jail in March of 2012. One of them gets arrested. My client had nothing to do with that boat. The government never alleged that with respect to Posmino, that my client had anything to do with that. So whatever that person is saying about my client's role, he couldn't possibly have known. He was in jail in March. The Mitsby launches in June. The other defendant—
Sorry, that's the guy who saw the silhouette, was in jail at the time he saw the silhouette?
No. The guy who saw the silhouette was one of the crew members on the Mitsby. Okay. But he also claimed that my client was not at the launch of the Mitsby. The government talks about two other that my client was transporting drugs. And
I see those. Okay.
They were both in jail when the Mitsby was going down. And they couldn't possibly, I mean, they say a lot of stuff, but it's just, with the court's indulgence, it's just garbage. The government, the evidence and the as I said, the gun, Your Honor, two things on the gun. The one who says the silhouette did not identify when he saw it. And it was not at the launch of the Mitsby because he claimed he was not. He claimed that Moreno-Membache was not at the launch of the Mitsby. The other gentleman, Paredes, who claims that he saw my client pull out a gun during a meeting, had on 5 previous occasions talked about meetings, the dates of the meetings, the locations of the meetings, the people present at the meetings, and never identified my client as being at any of the meetings. So he just says at a meeting, he sees this. And he says this 4 years and 7 interviews into these things. That makes no sense. The other thing is the court gives credence, the district court gives credence to what these guys say, because they say they're making statements against penal interests. These statements are not against penal interests. They're testifying, they're providing proffer agreement pursuant to proffer agreements. The other thing, the government just said that the record.
Wait, excuse me, Ms. Hernandez, what did you just say? Would you just repeat what you just said?
Yes, sir. The district court gave credence to what these cooperators said, because she claimed they were making statements against penal interest when they admitted that they had, like Paredes, who's been involved in, since 1995, he's a former Army.
Okay, and why were they, and why is she wrong about that?
Because these statements made by these cooperators were being made after they pleaded guilty, pursuant to, before they pleaded guilty, pursuant to proffer agreements in order to enter into plea agreements. When you give proffer agreements, when you give proffers pursuant to proffer agreements, what you say cannot be used directly against you. And these are statements about things they did years ago in Colombia. It isn't like, it isn't a local case where you can just add charges, but cooperators are never charged for additional statements they make. So one last statement the government made about the record.
Finish your sentence and then we're done. Finish your sentence.
One last statement the government made about the record being only the evidence at the hearing. I filed a post-hearing memo, which is attached as in the sealed supplemental joint appendix, which the court states it took into account in making its decision. And that post-hearing memo includes a whole lot of references to different statements from the record. And by the way, the government never sought to introduce any of these 302s. It wasn't that the defendants didn't introduce them. I was okay with the government with the introduction. The co-defendant said he didn't want to, but the government never sought to introduce them. So they can't stand here.
Okay.
Thank you, Your Honor. And thank you for all the time.
Thank you. Thank you both very much. The case is submitted.
Thank you.
Case number 19-5310, Margaret B. Kwoka, appellant versus Internal Revenue Service. Ms. Rosenbaum for the appellant, Ms. Lyon for the appellee.
May it please the court, Adina Rosenbaum on behalf of plaintiff appellant Margaret Kwoka. Margaret Kwoka is a law professor whose scholarly research focuses on government transparency and federal agencies' administration of the Freedom of Information Act. As part of her research, she filed a FOIA request with the IRS seeking copies of their FOIA logs, including the names of third-party FOIA requesters and the organizational affiliations of FOIA requesters, which the IRS withheld. On cross motions for summary judgment, the district court rejected all of the IRS's arguments for its blanket withholding of these records, saying that the agency's reasoning suffered from logical problems. The court required the agency to release the records subject only to limited redactions that the agency had to specifically justify, and the IRS subsequently released the vast majority of the records, which was thousands of names and organizational affiliations. Nonetheless, when Professor Kwoka moved for an award of attorney's fees, the district court denied her motion, concluding that although she was eligible for fees, she was not entitled to fees under the 4-factor test that this court uses to determine entitlement. In so concluding, the district court abused its discretion in 2 ways. First, it abused its discretion in weighing against Professor Kwoka the second and third entailment factors, which look at the requester's commercial interest in the records and the nature of the plaintiff's interest in the records. And second, it abused its discretion in weighing against her the fourth entailment factor, which looks at the reasonableness of the agency's initial withholding.
On the second and third factors, I wasn't sure where the district court was landing Can you help me understand? It certainly didn't seem helpful to Ms. Kwoka. Is it the nature of interest is both professional and pecuniary? You're reading that as a resolution of both those prongs against Ms. Kwoka?
Yes, I think the only way to read this sentence is that it weighed both of the prongs against her. It addresses both of the prongs, and the prongs often are considered together. It addresses both of them in one sentence that it begins with but. So it, in talking about the first factor, says that she has met that first factor, or indicates that first factor weighs in her favor. And then it says, but, to introduce the other two factors. So I think the only way to read this sentence is that it has weighed both the second and third factors against her.
And that quoted language from Cotton, I guess she called it Heyman, was language resolving a prong against?
No, that language from Cotton, Cotton didn't actually turn on the second and third. That's just sort of the language of the standard.
Okay.
So it's quoting the standard in doing that. On the second and third.
Mr. President, let me ask you about the fourth factor. So this is, given that this is a judge who granted summary judgment to plaintiffs. In other words, on the underlying case, she ruled for the plaintiffs. Yet she concluded that the IRS's defense was not unreasonable. So given that, and given what we've called our double dose of deference here, how do we conclude that she abused her discretion in reaching that conclusion?
I think the court abused its discretion by looking at the wrong factors, in particular in saying that the IRS had a reasonable basis ex ante in withholding the records. The court stated that its primary motivation was to ensure that it was not disclosing confidential tax return information. But the question for the fourth entitlement factor isn't about the agency's subjective motivation, whether it had good faith to withhold the records. It's about whether it had a reasonable basis in law for withholding the records. And when the court addressed the legal basis for withholding the records in its summary judgment decision, it found that the agency's reasoning suffered from logical problems, that the agency's conclusions did not follow from its premises.
Wait, you just broke up. Could you just say that sentence once again?
Sure. So the question,
the last word I heard was logical.
Sorry about that. So the agency,
no, it's not your fault. Yeah.
In its summary judgment decision, the court concluded that the agency's reasoning suffered from logical problems, that its conclusions did not follow from its premises. So when the court,
but notwithstanding that, she concluded that the agency's position in the underlying litigation was not unreasonable.
Right, but in doing that, she looked at the wrong considerations, particularly at the motivation, the subjective motivation.
But she went on to say that the position was substantively reasonable. She didn't rest only on good motive.
Well, the other thing that the court pointed to in saying that it was reasonable was that the redactions showed that there had been some legitimate cause for concern. But looking at the redactions also involves examining the wrong factor, because the question isn't whether there was a reasonable basis for withholding the records that the agency ultimately withheld. And Professor Kwoka did not object to those redactions. She did not challenge those redactions when the agency made them. The question is whether the agency had a good faith basis, reasonable basis in law to withhold all of the records that it withheld at the beginning, including all of the ones that it eventually released in the case. So we think that in determining that that the agency had a reasonable basis as an ex ante, that the court was examining the wrong considerations and not looking at whether the agency had a reasonable basis in law for withholding all of the records that it originally withheld. And what it did
is the ex ante point in time that we're talking about is the initial decision for blanket withholding
Yes. So the question is whether it had a reasonable basis to withhold.
at that time, to do a blanket withholding,
To do a blanket withholding at the beginning of the case.
to not determine whether it could segregate portions out.
Right, whether it had a reasonable basis for not complying with its obligations to segregate out the non-exempt
And as
records.
to that, its reasons were new document, which the district court flatly rejected,
Yes,
and administrative burden, which the district court flatly rejected.
yes.
So that's what we're comparing, looking at right now, is the justification, whether the blanket withholding on those two grounds was reasonable.
Whether there is a reasonable basis for the blanket withholding overall, yes.
Right. Those two grounds, and then the concern was there might be something in here some things in here that will disclose stuff covered by 6103, and we're not going to look any further because new record administrative burden.
Well, the agency overall did not engage in any segregation. It was not willing
Because
to
of the
segregate.
administrative burden and new document arguments.
Yes. I would like to briefly touch on the second and third entitlement factors as well. The court abused its discretion with regards to those factors by failing to apply this court's decision in Davie and ignoring Professor Kwoka's scholarly interest in the records. In Davie, this court made clear that scholars were precisely the type of requesters that the FOIA's attorney's fee provision is for, and that generally the second and third factors should weigh in favor of scholars, of people with a scholarly interest in the records, unless they have a purely commercial interest or their request is frivolous. Here, Professor Kwoka's interest was clearly scholarly. She sought this information to use in her forthcoming book and in other scholarly works. Her interests were not purely commercial or frivolous, and those two factors should have weighed in her favor. She is the paradigmatic scholar seeking information for public information purposes.
There's a third possibility on factors 2 and 3. They could be resolved in the requester's favor. They could be resolved in the government's favor, or they just might not cut one way or the other. And you cite Davie, which is a very good case for you, no doubt about it. But post Davie, we have McKinley, which says that when you have a requester with both motives, the commercial and the scholarly, it's not an abuse of discretion to conclude that that factor falls in the middle category. It doesn't cut one way or the other, right? So why shouldn't we understand the district court basically to have been acting consistently with McKinley rather than inconsistently with Davie?
I think the only way to read what the district court did was to weigh those two factors actually against Professor Kwoka.
Factor 1, she resolved in your favor. And then there's the but.
There's the but, and the only thing that
the but means she's not resolving factors 2 and 3 in your favor. But where do you get that she's resolved? She's counting them against you, which would be a Davie error, as opposed to just saying, I'm not counting them one way or the other, which would be fine under McKinley.
I think that the but does indicate that it's saying something opposing, and then the fourth factor is introduced with moreover. So I think that the structure of the decision makes clear that she's weighing the first factor in favor of Professor Kwoka, and then the last three factors against Professor Kwoka. I think also looking at what the court took into account on the second factor.
Just back up there too. McKinley, the requester, was someone in business for himself as a regulatory policy expert, not an academic, with no real history of academic publications. So do you read McKinley as changing Davie to say that when you're an academic and you're also publishing a book, it's a draw on 2 and 3? I hadn't read McKinley that way.
I don't think
academic.
I don't think that McKinley changes the that overrides Davey in that way. And I think
it didn't involve an academic, and we talked a lot about academics, because otherwise, I don't know why a newspaper reporter was writing a book, say about bringing down Harvey Weinstein, or Jeffrey Epstein or something, and because that was federal government, did a FOIA request for that.
And I think here there's just no basis for finding that Professor Kwoka's commercial interests outweigh her scholarly interests. And the district court, again, did not take her scholarly interests into account at all. It only talks about her commercial interest, her pecuniary interest, her professional interest. There's no recognition that she was seeking this information for public informational purposes, which is the way in which scholars seek information. So it ignored her scholarly interests overall. There is no basis here for finding that her commercial interests, and the only possible thing that the court could have been referring to in talking about her commercial interests is the fact that she earns her living as a scholar and is publishing a book, an academic book about FOIA. But in Davey, this court recognized—
books like that make much money?
I would not expect that book to make a lot of money for
your
her.
client.
Does that make, under your theory though, does that really make any difference?
I don't think it makes a difference how much money the book will make. I think at the extremes, there could be, if someone, if it becomes clear someone is really publishing a book solely for private pecuniary.
No, but I was asking you the question about her, a scholar, a university-based scholar.
Right, I think that a professor—
Does it make a difference? Does it make a difference? Are scholars who write books like this treated differently from scholars who write Econ 101 that's used by every freshman in the United States?
I don't think it makes a difference. I think if the purpose of the book is scholarly and it's being written for an academic purpose to be increasing the public knowledge, then the amount of money that the professor is making doesn't make a difference. That's just how part of—
Okay, great, thank you. Unless either of my colleagues have any questions, you're out of time.
Thank you.
Anything else?
Nope.
Okay, we'll hear from the government.
Thank you, Your Honor, and may it please the court. My name is Kathleen Lyon, and I represent the IRS. The district court here properly exercised its broad discretion in denying Professor Kwoka's request for attorney's fees because, first and foremost, the IRS had a reasonable, or at least a colorable basis in law for withholding the documents, principally to ensure compliance.
What supports your statement in your brief that that's the most important factor?
In our brief, well, because
don't you say the fourth factor is the most important?
Yeah, we say it's the most important here, we think, because because we think that—
Oh, you mean here?
Yes. We're not saying that the fourth factor is elevated above other factors.
Why is it the most— Oh. Well,
I'm sorry, you're breaking up here.
You think it's just the most important? You think it's just the most important in this case?
Correct.
And why is that?
Because we think that factor standing alone would be sufficient to affirm in this case. For example, under Morley 3, this court found that even though factors 1 through 3 weighed in favor of the FOIA requester, the plaintiff in that case, that factor 4 was enough in that case because it weighed strongly enough to support affirming the court's denial of the award of fees. And we think this is a similar situation, that even if, the first 3 factors weighed in Professor Kwoka's favor, that the district court's finding that, or determination that— yes.
Here's my question about this factor. So you devote several pages in your brief to the proposition that the service was motivated to protect confidential return information. That's what its motivation was here. And of course, that's true. I mean, no one would disagree with that. But the question we have to ask is, why was it reasonable to think that this particular FOIA request, this one, would result in the release of return information? That's the question. And I didn't see anywhere in your brief where you responded to that.
Well, I think what we've...
The district court in her summary judgment motion said that basically the IRS's position on that issue didn't make any sense.
Well, the district court found that there were logical problems with that argument. However,
Right.
The district court is very familiar with its own opinion, and it found, even despite that the district
Yeah, I know that, but we still have to review it. We have to review it. I asked counsel for that same question. You're right. It is significant that this is the same district judge who granted summary judgment for the plaintiffs, but we still have to ask whether it was an abuse of discretion. And my question to you is that I didn't see in your brief anywhere where you explained that why it was at all reasonable to think that this particular FOIA request would result in the release of return information. Well, that's what I don't see. I mean, well, it seems to me just to, go ahead.
I'm sorry. Okay. Well, at our brief pages 28 and 29, I believe, we set out that the question that was posed by this FOIA request was a novel legal question about which there wasn't any specific guidance. There wasn't any precedent. There wasn't any specific exclusion in 6103 that would answer the question of whether third-party FOIA requesters and the organizational affiliations of FOIA requesters would, when combined with the subject matter of the FOIA request, result in an indirect disclosure of return information. And so it was a novel question that arose in a familiar framework of 6103. And of course, 6103 has these extremely broad definitions of return information, and disclosure. And it's established that that when information is aggregated with other information, if that poses a great risk of disclosure of return information, that also is prohibited. Now, the FOIA law keeps it clear.
What about this case? What about this FOIA request? I mean, they rejected it. They didn't offer any to turn over some of it with redactions as a blanket rejection. Correct. And the question is, why was it reasonable for the IRS to think that that this request would result in the disclosure of return information? Why was that at all reasonable, given everything the district court said?
Well, if I could step back for a moment and perhaps give a big picture look here. Now, of course, the FOIA log itself is not 6103. It wouldn't be a public FOIA log if it were. But the vast majority of FOIA requests that come to the IRS are asking for return information for very common sense reasons, because people generally don't ask the IRS for documents that don't exist or for documents.
I'm sorry, when you say the vast majority, the Roe Declaration said you get many requests for that, and you get, quote, many, quote, requests for non-return information. Are you disagreeing with that declaration now when you say the vast majority seek tax information?
Well, I don't think it's incorrect to say that there are many requests that are for non-return information, but those can be split between
the vast majority when there's many for non-return information. And this one included a request for non-return information, as well as your concern about return information.
Well, it asked for the names of organizational affiliations. It didn't necessarily
including those FOIA requests that were for non-tax information.
Well, correct. But the problem for the IRS is that looking at when Professor Kwoka's request comes in, suddenly she wants to associate names with everything on the FOIA log. And the automated system, of course, can produce a list of names of the requesters and their organizational affiliations. But the IRS can't release that list without risking violating 6103 because there's no way to distinguish.
Well, I want to hang on. I'm sorry.
Why? That's our question. Why? You keep saying that, but why?
Well, because the automated system has no way of distinguishing between what's a first party request, what's a third party request, what's a request for tax information or tax return information, what's a request for non-return information. And so we think that, given the broad definitions in 6103, the IRS has to make a judgment call about the risk of 6103 violations. And And this was a very novel and complex request. And so the IRS's concern there was reasonable, or at least a colorable basis in law. The fact is that
sorry, I just want to be crystal clear here.
Yes.
Roe's declaration said you get many requests for non-return information. And this was just for a year, 2015. So there's no reason to think 2015 would have been different than other years. It would have included many FOIA requests for tax return information and many for non-return tax information. Right. And then Roe's declaration specifically said, disclosing the requester names and organizational affiliations with respect to those requests for non-tax records would not reveal tax information under 6103. And 6103 itself, you got to read the whole thing, says that its protection does not include data in a form which cannot be associated with or otherwise identified directly or indirectly a particular taxpayer, which is exactly what your declarant, Mr. Roe, said. We would have had many of those in 2015, correct? You don't disagree with your own declarant, right?
No, Your Honor. What I'm saying is that, all of that can be true, but the IRS...
You had a lot in there that wasn't protected by 6103. You thought there might be some that if things got pieced together, or you worried, I guess there were some, and that's conscientious.
You're worried that there were a lot, that this was
it turns out
all going to be a problem.
Close to a lot, but you didn't know. You didn't know.
Right.
You didn't take any inquiry.
Well, the IRS couldn't tell based on
It couldn't tell without looking. That's what Mr. Roe said.
Correct. They couldn't, and we also argued, of course, the unreasonable burden.
Right, and the district court flatly rejected that as not a reasonable argument.
Well, it did that based in part on Public Citizen, in which case...
I'm not asking what cases they cited. The district court just found no merit to that argument at all.
Well, correct, but it didn't find that was, the district court here didn't find that that would have been an unreasonable basis for our argument. It just said that the IRS was wrong. And, there are distinctions between Public Citizen and our case here, specifically that the reason that
the case about you had a concern that there might be some in there. I didn't see in your any declaration that said you were concerned that lots and lots would be in there, but you were concerned that there would be some in there in 6103's
correct
important statute. And then, as I read the process, what happened is then what the government said is, and we're not going to look and check to see because it would be too much work.
Because
all the documents, it would just be too much work to look. That was the position.
Yeah, that it would be an unreasonable.
It wasn't that we know that we think there's lots. There's no declarant I saw that said we think there's lots in there that are protected by 6103. I didn't see that quantification. If I'm erroneous, please tell me. It's just that it could be one, could be 200. We have no idea.
Correct.
We know there's a chunk in there that won't release tax return information.
There's some that may not. Yes.
We know many will not include tax return information, according to Mr. Roe's words. But we're not looking. And so isn't that what we're deciding, whether the district court was correct to decide that position was colorable under FOIA?
Well, I think the colorable bar is a fairly low bar. Considering...
We're not going to bother looking?
No, Your Honor. We made a
exactly what Mr. Roe said. We're not going to look. It would be too much work.
Correct, and it is perfectly legitimate for
after summary judgment, and it turns out it didn't.
Correct. It turns out it didn't, but the reasonableness factor is determined, earlier in that process, at the time the IRS is making the decision. And in light of the fact that
there's something when Mr. Roe described why it would take a lot of work that he was wrong about, because he just said how many documents and how many hours.
Yes, and our other declarant, Corinna Smith, also laid out the number of hours and why it would take that long.
Okay, so were they just wrong about that? It looks like it took a decent amount of time. It took, I don't know, 8 or 9, 10 months, something like that. Maybe it was.
Yeah, well, there was also the government shutdown in there. That was the 5-week shutdown. And so it did take a good deal of time to do it. And Corinna Smith, I think in particular, in her declaration, laid out why that was going to be the case, because of the way
I'm
the
just saying
system
that there's
works.
no gap. You said it turned out it didn't take that much time, but there wasn't anything. We have to assess it at the time the government made its decision to do a blanket withholding.
Correct.
Okay?
And I guess,
and the rationale given was one that the district court flatly rejected. Just said that's not how FOIA works. Said that is not how FOIA works. You have the documents and you have to check them.
well, it said that the volume of the documents was not enough to.
No, but it also said your unreasonable burden goes to search, not organizing the documents when you have them.
Well, as we've cited, I think it's Solar Sources and American Federation of Government Employees, which both stand for the proposition that, where the search is, the unreasonable burden question goes to search and review. And I think under Solar Sources, that case said that where this is going to be significantly unwieldy, as it was with our
right. And the
FOIA
district court
system.
rejected both. That you can't. First of all, the cases you cited involved search, and that your sense of unwieldy was off base for FOIA purposes. I mean, it takes a lot bigger numbers and a lot more hours under FOIA. You weren't in the neighborhood.
Well, the district court didn't pass on the number of hours. It passed on the volume. And it also, again, the case that it was relying on, Public Citizen, went to the lack of sufficiency of an explanation in the affidavits.
Do you have any case for the district court or one now that says the amount of documents and hours, all that was at issue here, or something in that range at issue here? Post-search, search is done, not talking about unreasonable search, that just going through this many documents and what would take this many hours is too much of an obligation for an agency to have to execute under FOIA? Do you have any case that said that?
I don't have one specifically, no, Your Honor.
You didn't have any case?
But we don't think, I mean.
Did you have anything close?
I don't think so.
You didn't have any legal authority on point for your assertions?
Well, not specifically, no, I don't think so.
Okay.
So my time is up. Does the court have any further questions?
I had one more. You also invoked FOIA Exemption 6.
Yes.
I don't know if you've abandoned that or not.
Well, we didn't appeal the order, so we're not, disputing.
I mean, as to reasonableness.
As to reasonableness, well, I mean, we noted it briefly in the brief. I mean, the fact is, on reasonableness, the court was looking to 6103 primarily. It wasn't looking to Exemption 6, and so we didn't think that needed that much addressing because the district court only needs one basis to find a reasonable basis. But we, as we said in our brief, we think under Exemption 6, the rationale is essentially the same because the court found.
Under Exemption 6, you have to show that there would be a clearly unwarranted invasion of privacy. And your affidavits, again, at the relevant time here, invoking blanket exemption, said maybe, may, and may, which is not the standard for Exemption 6. That might work under 7C's privacy protection, but not Exemption 6, which requires would.
Correct.
So then it's not the same. So I don't know how you can just say if it's 6103, if we have a 6103 concern that also satisfies Exemption 6, given that Exemption 6 has a very strict standard. Would violate, would infringe.
I'm sorry, just to be clear, we're saying that the district court's opinion found that for much the same reasons that our arguments under 6103 were not persuasive, they were for the same reasons not persuasive.
But that would be legal error then, plain legal error, which is always an abuse of discretion because 6.1 says Exemption 6 requires a finding that there would be a privacy intrusion, not that there may or might be a privacy.
I guess I'm perhaps confused by your question. I mean, the district court found against us on that, and we didn't appeal. So
I'm talking about again on the reasonableness of your legal position.
Well, I don't think that we needed to particularly defend on those grounds. I mean, the district court found that there was reasonableness under 6103.
I'm sorry, I thought you said your brief had raised it again. So
well, we just
understood.
Well, correct. I mean, in the section where we address that very briefly in our brief, followed by our addressing the unreasonable burden standard, we said that the district court, had sufficient grounds under 6103, and therefore, you only need one reasonable basis.
Okay.
All right.
Thank you.
Thank you.
Thank you.
Ms. Rosen, yeah, thank you. Ms. Rosenbaum, you are out of town, but you can have 2 minutes.
Uh-oh.
Sorry for that delay. Because all of the 4 factors here weigh in favor of Professor Kwoka, we think this court should hold that she is both eligible for and entitled to fees, and remand to the district court to award her the fees that she requested. And unless there are any further questions. Thank you.
Any further questions? No? Okay, well, thank you very much. The case is submitted.
Case number 19-5336, Fort McDermitt, Paiute and Shoshone Tribe versus Alex M. Azar II, Secretary, U.S. Department of Health and Human Services et al., appellants. Mr. Dos Santos for the appellants, Ms. Patterson for the appellee.
Good morning, may it please the court. Josh Dos Santos on behalf of the Indian Health Service. The Indian Self-Determination Act allows tribes to take over programs that IHS runs for their benefit. The point of the act in this context is to give tribes greater agency over the provision of their healthcare. So whereas by default, the tribe gets the healthcare from the federal government through IHS, the act allows a tribe to exercise agency and then provide healthcare services for itself. The issue in this case arises from the fact that IHS often provides services for more than one tribe through the same program in order to conserve resources. Congress foresaw that circumstance, which is very common, and it dealt with it in the following way. It expressly prohibited tribes from taking over a program in which more than one tribe has a share, unless the other tribes consent, which makes sense given that the act is about self-determination and agency. And if one tribe could take over a multi-tribe program without the other tribes having a say in the matter, that would eliminate the other tribe's right to self-determination without their consent. And then second, Congress gave IHS authority to sever and redesign a program that served more than one tribe so that it could accommodate all of the tribes that are affected. That's a common sense approach to the issue here. And the district court's ruling contravenes those principles. What the district court said was, when there's a multi-tribe program, the first tribe to ask to take it over gets all of the money, not just its share. And that would effectively deprive the other tribes of the opportunity to provide for their own health care.
Can you just help me out? There's steep learning curve on this case for me. How do you define tribal share in this case?
So tribal share is a longstanding concept. It means the portion of appropriated funds that IHS allocates on a per tribe basis to each tribe for their benefit. And the way it works is, as the Supreme Court has previously talked about and acknowledged in both Lincoln versus Vigil, and then again in Salazar versus Raymond Navajo, IHS receives lump sum appropriations, and in consultation with the tribes about their needs, it then allocates those funds on a per tribe basis.
So the way it seemed to be described here, and I may totally misunderstood this, was it was this large number. It was 190,000 or something like that for the Winnemucca tribe, which seemed to be a lump. Was that just a lump sum that was for all their healthcare needs, or that was they get a bigger sum than that, and that was the amount that was dedicated to the clinic program?
There are different buckets of funds. So the one at issue here is hospital and clinics funds, direct medical services. And for direct medical services, IHS applies a longstanding formula and to all the tribes in the region. And the Winnemucca share was 190 under that formula.
For this,
and
that was all going into this clinic.
This clinic, exactly.
Even though they were getting a lot of their, I thought, this is one thing just confused me, and you're the expert. As I read the record, they were getting almost all of their, I think I would call it direct medical care, but maybe that's my error, through a different process. It sounded like just sort of a direct reimbursement, provider reimbursement process or something like that. Not at this clinic. You know the record. There's two people, maybe
yes.
6 people. Was that included in their agency share, or was that dealt with separately? Am I wrong to say that both the same?
That is dealt with separately. So that's what's called purchased and referred care. And that's a separate bucket where IHS pays third parties to provide care. But it's different from direct medical services.
Then why was Winnemucca, why did it have so much money attributed to this clinic when there were so few members using it? And I think the record says, is it 25 or 50 other tribes would have people who would sort of show up now and then, just because I take it the clinic would be open to other people who come in, so you don't have to sort of show tribal membership to get in the door. And the Winnemucca just seemed to be much like them, just a few people a year now and then. So why is it that they had this large share, but none of these other tribes that were also using the clinic did? And why $190,000 for 2 people?
Well, so I think what would clarify this for Your Honor is that shares are not allocated based on how many people end up using a particular clinic. They're allocated based on how many eligible potential users live in the geographic area that's assigned to each tribe. What happened here was IHS used that formula, taking into account how many eligible potential users live in the Winnemucca's area, and allocated shares accordingly. At the time, the Winnemucca tribe did not have a functioning government. And you can see in the record, page 244, there were several factions that were vying to be the Winnemucca's government. So IHS couldn't consult and get a determination as to where Winnemucca would prefer its 190,000 to go. And
my understanding is that, so that because they didn't have a functioning government, IHS or the secretary, I'm not sure exactly the level, was making the decisions for Winnemucca as to where those funds should go.
Well, IHS always makes the decision. It's in consultation with the tribe, but it always makes the decision. And I do want to highlight the point that Your Honor made about the fact that clinics are open to members of all tribes. I think that's an important point to keep in mind, because it shows that allocations, the shares don't depend upon how many members of a particular tribe use the clinic. It's not the case that if several members of a different tribe come and use the clinic, now that tribe acquires a share. The shares are determined by IHS under a longstanding formula that isn't challenged here.
But in the operation of the clinic, I take it Fort McDermitt has been operating the clinic now for a few years or years?
That's my understanding, yes.
Right. They would still service however many Winnemucca people, members of the Winnemucca tribe, I'm speaking too quickly, came into the clinic. They would still provide them medical services just as they had before? Or would that change with the share withdrawn?
No, that's correct. Tribes are required to provide care to anyone who comes through the door. But the point is that if the Fort McDermitt tribe takes the Winnemucca's funding share of direct medical services, then there is no money available for a program that the Winnemucca tribe could take over. So in other words,
but until they do, I mean, it seemed to be what Interior was doing before, or the BIA was doing before, was, you said it's your decision. It's not really Winnemucca's, because they didn't have a government, a functioning government to make a self-determination decision at the time of your final response, your response to their final offer. And so it was your decision where this money should go, and nothing on the ground changed. They were going to keep serving these same individuals. I assume till today, as of today, would still continue to serve these same individuals, even though now the Winnemucca have a functioning government.
So let me clarify. The things on the ground would not stay the same because the Winnemucca would have no opportunity to exercise its right of self-determination under the Act. And in fact, IHS could not take the money away from the Winnemucca and did not have to for the following reason.
Could not when, like at the time of this your final response letter?
Yes.
I think you just said that Interior makes the decision and you just consult with the tribe.
That's right. But Congress specifically said that a tribe can't take over a multi-tribe program without the other tribe's consent. And because as it stood at the time, Winnemucca had a share here.
Well, how do we know this was a multi-tribe program? What is that? I don't know how we know. Some of those, it looks like consortiums where the tribes themselves actually get together and take over a service from IHS or BIA generally, I guess, other types of services. But here it was being run by IHS. So how was it a multi-tribe program when it was run by IHS? Just because you allocated the funds there?
It's because IHS allocates funding shares for particular programs on a per tribe basis. And you could see how Congress acknowledges this in the statute. In section 5324I1, it says in particular, sometimes a contract will, quote, require the secretary to divide the administration of a program that has previously been administered for the benefit of a greater number of tribes. You see it also in the fact that in the funding provisions in Title V.
But you're not dividing anything. I don't get what was divided here. They're still providing exactly, I mean, maybe they've improved it, but for our purposes, the exact same health services accessible to Winnemucca tribal members as they were before. So it wasn't as though Interior divided anything up. I mean, if it had said, fine, you can run it, the Winnemucca will not go there anymore, it will just be your clinic, that would make more sense. But I don't know, what division was made here in the program? What division in the program was made as opposed to behind the scene funding allocations?
The division is the funding allocation in this case. The tribe now has only...
Talk about dividing a program? Divide the administration of a program. That's a provision you just pointed me to. It doesn't say divide funding. You have to divide the administration of a program, which makes sense if two tribes are both taking over different parts, or if a tribe was taking over one part and Interior was going to keep operating its own part. But the program here, I was wrong. How is it divided? How is a program here, the clinic? We'll call the clinic the program. How is it divided?
Let me explain how it works. You have a program that's supposed to benefit multiple tribes because IHS allocated funding shares for multiple tribes. One tribe comes to the door and asks to take over the program. The way in which the tribe gets to administer the program is negotiated. Maybe they want to run it in exactly the same way. But the point is, they can't take everything because another tribe has a stake here. And so IHS says, here's what you could take. Sometimes it's including the building and it's going to use the other tribe's share in a different way. Sometimes there's more line drawing to be made. But in this case, what happened is IHS said, fine, you could take the building, run it if you want to run it the same way it was being run. But the portion that the Winnemucca had here, funding, we're going to use for them once they tell us, how they want to use it.
And you pointed me to the statutory text here. And what you're talking about is we're going to divvy up the funding now. We had been giving you two sources of funding. Now you're going to get one. I think am I correct in reading the record that while it served a lot of other tribes, none of them had funding allocated, right? It was only, right. Is that right? Okay. At least as to the clinic. I don't want to know about EMS. But the statute says divide the administration of a program. And it doesn't say divide the funding. That's why I'm confused.
Well, let me point you to section 5388 as well as section 5325A1. 5388.
Okay, one at a time. Okay.
Sorry. Yes.
Yep.
So if you look at section 5388C and multiple other places in Title V, it talks about the funding that a tribe gets as its tribal share. which is referring to this very same concept. If you look at—
Sorry, you're in which, in C?
5388C, that's right. That's this concept that we're talking about. When you look at 5325A1, it explicitly refers to the fact that funding might be for only a portion of the program. So Congress knew that IHS—
Wait, there's nothing, I'm not seeing that in
I'm
not seeing it in 5388C. Am I missing tribal share? You said the tribal share is in here? That just refers me to 5325A1 and contract support costs.
So 53, give me a second here.
I'm sorry if I'm not seeing it.
Mm-hmm.
You said 5388C, right?
I did. One second. I believe if you look at, sorry, it's 5385B and 5388D. So 5388D refers to the full share of a tribe. 5385, you see 5385 funding agreements. Section B1, it states the Indian—
I'm sorry, we got to go a little bit more slowly because 50D is pretty complicated. I'm not quite sure that's as clear as you might want. But what was the second one you said?
So the point in D is that
85B
it refers to the full share. 5385.
Well, it does use the phrase full share, but I'm not sure that gets where that gets you.
If you look at 5385B, when it's talking about funding agreements, and how much the—
Sorry, I got to switch through a lot of things here. 85B, okay.
Mm-hmm.
Okay.
It again says receive full tribal share funding. And then Congress defined tribal share as, you know, the portion that a tribe has in a program. And let me
Wait,
also—
where's that definition? Is that 81? Is that the one you're talking about?
That's right, 381A8.
Right, but that's got the portions thereof, and the portions in 5325A1 again is talking about portion of the program, not portions of funding. So I just find this really confusing, and alas, this isn't an area where you get Chevron deference. Unfortunately, that would help a lot, but you don't. So
let me try to clarify something about the program. When a tribe is negotiating to take over a program, there's sort of flexibility into how the tribe is going to run it, whether it's going to run it in exactly the same way or not. So here the tribe could say, we want to run it just like you were running it. And if we can only, like say there was no dispute here and they agreed, the Winnemucca has a share that we can't take over. They could say, we want to run it just like you were running it and just take away the funding that went to Winnemucca, and Winnemucca can do, you know, whatever it wants with it. It could do that. So IHS could give it the building, they could run it the same way, just with
could IHS do that if it would imperil access to health care for another tribe that doesn't have, at least at the time, the wherewithal to take over its own health care? Or it would be quite expensive then for IHS to open up another clinic, you know, a couple of miles down the road?
Well, because IHS has other options, but that's the—
I mean, I'm just trying to say, IHS could approve something in that situation like that? I would think there would be some breaks within IHS on that in a situation like that.
So I take Your Honor's question to be, when IHS has a program where multiple tribes have a share and one tribe wants to take over its share, but IHS couldn't really provide healthcare services with the remaining share for the other tribe? Is that what you're suggesting?
But the tribe that is taking over, you just keep saying taking over a share. What they're taking over here is a program, the clinic, okay? And they're taking over the full clinic, and they're continuing to provide services to the Winnemucca tribe exactly as they had before. Nothing has changed in the real world.
What has changed is the Winnemucca wouldn't be able to take over anything. It wouldn't be able to exercise self-determination.
But they couldn't anyhow at the time of your decision.
But now they can. I mean, they have a government now.
Okay, but at the time of your decision, you were the one making that call, not the Winnemucca tribe. And so that's why it seems odd to me the secretary said, we'll have our cake and eat it too. We'll get the exact same clinic. We'll continue to ensure that the Winnemucca get just as much services at that clinic as they did before. and budgets are always tight. Now we're going to take away that $190,000 that was dedicated to two people.
It's not that it was dedicated to two people. It's that it was dedicated to a tribe on the same
I know,
basis
but in
every other
practice-
tribe got money.
Okay, but on the ground, it was taking care of two people, which,
But that was, what I want to emphasize is that was due to the happenstance of the moment, that Winnemucca couldn't advise as to where it would have preferred it. Going forward, what this means is every other tribe in the region has a certain amount of money based on a formula that applied equally, that allows it to take over direct services under the Act. Winnemucca will not. And the Fort McDermitt tribe will have a greater share than everybody else. That's what's going to happen on the ground. And as to the program issue, IHS has authority to redesign. It could leave it looking just how it was and say, in order to meet the needs of the other tribe, we're just going to leave you the clinic and meet the needs of the other tribe another way, which is what it did here.
it's just, is it unusual? I'm sorry, go ahead.
How would it do that?
So with the amount of money, it could either start another program, it could dedicate it to buy more third-party services, which is what it has been doing, my understanding is, in the years after this.
Wait,
The status quo ante, like pre-Self-Determination Act, is that the Indian Health Service would be operating this entire clinic, and for the benefit of mostly the Fort McDermitt, but also the Winnemucca and whoever else uses it, right? And let's say it costs them $1 million to perform all of those operations for all of those tribal members, right? Now the Fort McDermitt come in and want to take over all of those operations, and 5325 tells us that they should get the amount the secretary would have paid to operate all of those programs, which is all of the services for all of the people who use that clinic. That's what's happening. And 5325 says they're entitled to that full $1 million, right? There's no, IHS is not running part of this clinic, nor are the Winnemucca running part of this clinic.
Let me back up and sort of explain further how this works. IHS says, here's how much money I'm going to allocate for the Fort McDermitt tribe to meet its needs. Here's how much money I'm going to allocate for the Winnemucca tribe to meet its needs. I'm going to put that money into this program to meet both of their needs. When the Fort McDermitt tribe asks to take over the program, 5325 foresees that sometimes it's going to only be able to take over a portion of it, right? Fort McDermitt tribe comes to the door and says, I want to take over the program. IHS says, well, some of that money was supposed to be going for Winnemucca, and if we give you all of it without Winnemucca's consent, it would violate the statutes, and Winnemucca would have no ability to then take over anything and exercise its right to self-determination. So on the ground, what plaintiffs principally point to is the fact that the allocation that IHS made for Winnemucca did not end up benefiting Winnemucca members on the ground very much. But the answer to that is not to take the Winnemucca's share away. The answer to that is to let the Winnemucca, now that they have a government, say how they would prefer this to go. I mean, this scheme is not a use it or lose it scheme, and is not one where a tribe acquires other funding allocated by an agency to a different tribe through adverse possession of some kind. And Congress explicitly said in two places that a self-determination contract request does not require the agency to take money away from one tribe and give it to another.
I ask, follow up, you said that you've actually been using these funds now to provide more, if I've got the terminology right, direct services to the Winnemucca tribe since all this happened, or what? So, the PRCs or whatever you call them.
The way it's worked is IHS has ended up buying more PRC. In other words, the one that IHS pays third parties to provide services. Sure. But let me just emphasize that those are different from direct services in several ways. One is that the tribe can't sort of take it over to operate it itself because it's a third party providing it. The other is that these funds are supposed to be more of a backstop in cases where a tribe can't get services elsewhere.
Sure.
The tribe is usually supposed to request IHS authorization before it even gets the care. Sorry, the person who wants care is usually supposed to request authorization from IHS. There are all sorts of requirements that
I
must
get
be
that's
met.
different. I was that's helpful to think about, but I was curious because you said that's what you've been doing. So you've increased that since I don't know what years, but since the rejection letter by IHS. But there's an injunction in this case that wasn't stayed, as best I can tell. So I had thought that at least as the litigation progressed, Fort McDermitt was getting the funding ordered in the district court's injunction. Is that right?
No, Your Honor. The tribe has been getting the funding that IHS approved as a matter of the severance. So it's gotten everything that IHS said is your portion. But
wait, there's an injunction in this case from the district court, is there not? That they were to get their requested amount, right?
So I believe that the district court said they should, but it did not
There's an injunction.
It did not state a date certain, and there's no indication that it didn't intend for IHS to be able to appeal.
I'm sorry, I'm incredibly confused. I thought the tribe comes in and makes an offer. The government can reject it. They challenge that rejection. The district court said, you win. In a final judgment, we're not here on a PI appeal. In a final judgment, you win, Fort McDermitt, and you have an injunction for the amount that you said you needed. But the government just hasn't been giving it to them?
Well, again, Your Honor, the district court didn't say turn it over immediately, didn't provide a date certain.
Well, how many years has that injunction been in effect now? And you didn't ask for a stay?
It was 2019. It was like October.
So a year, an injunction, you don't have to comply with an injunction for a year? 2 years? I'm very confused. I had assumed you were complying with the injunction pending litigation because you didn't ask for a stay. But
my understanding
is, did the district court know you're ignoring its injunction?
My understanding is that IHS gave the tribe the portions that were approved, which 5387 says it should do, and the district court didn't say do it immediately, and the Fort McDermitt tribe has not. I think both parties understood this to mean IHS could still seek an appeal. There was no date certain.
People can seek appeals while there's injunctions. I'm very surprised. I thought, of course people can appeal when there's an injunction in place, but you either comply or you stay it. But apparently I hadn't realized that ignoring it was another option. Okay.
Mr. Condas, I have just a technical question about the rejection letter.
Sure.
Which I'm asking because as I understand this statutory scheme, there's a two-stage process here, right? The first question is, did the service properly raise the issue in the rejection letter? And if it did, then you get to the merits, right? So my question about the rejection letter is, what in that letter says that the clinic had been funded with money allocated to the Winnemucca and that the Winnemucca had a portion of the clinic?
Your Honor,
and the reason I ask it because if it isn't there, and I'd like you to point me to the precise language, because if it isn't there, then if it isn't there, then I don't understand how the rejection letter provides what the statute calls specific findings.
Your Honor, if you look on page 123 of the joint appendix.
Are you looking at the rejection letter?
Right, which is the rejection letter. IHS says,
what does it say?
IHS says, IHS has determined that the tribe's share of hospital and clinic funds is a certain amount minus retained services, comma, as reflected in the exhibit. Should Winnemucca authorize the tribe to carry out the services on Winnemucca's behalf, an additional $190,000 would be made available. To date, the Winnemucca has not authorized the tribe to carry out services on its behalf. The IHS therefore rejects the tribe's proposal. IHS is clear, and you also have multiple instances in the record, such as JA 40 to 41, and then the closure report that was attached to the rejection letter stating that Winnemucca tribe has a share. IHS is clear. Winnemucca has a share. Fort McDermitt can only take its share. That provides what the statute requires, which is a reason with the controlling legal authority, which it cites here, 5381.
Okay, Judge Millett, Judge Katsas, do you have any further questions?
I had one more. I just want to make sure you were done with your questioning, Judge Tatel.
Yeah.
I wanted to go back. You said they couldn't get these funds without the consent of the Winnemucca tribe. And at the time, my understanding is because there's no functioning government, IHS or someone in Interior was making those decisions for the tribe. Is that how it works when you have a tribe with no functioning government?
When you have a tribe with no functioning government, the tribe can't consent to another tribe taking over. And
Can Interior make that decision for it?
No. So it's not the case. Let me try to explain. IHS always makes allocation decisions. It just consults with tribes. But when it's the case that one tribe wants to take over another's share, Congress requires a resolution by the other tribe. IHS can't substitute for that resolution.
And Congress requires that resolution. That's one of the ones you pointed me to?
Yes. So in 5381 C1B, which are one of the eligibility provisions under Title V. I'll repeat that more slowly. Sorry. 5381.
5381.
C1B. And then 5304.
I apologize. I don't have a C in 5381. Got an A and a B. There's a definition of tribal share, but not where it says there has to be a resolution from the tribe. And so if there's no functioning government.
Oh, sorry, 5383 C.
5383. Okay, sorry. There's a lot here.
I know.
C1.
B states that it needs resolution of the governing body of each Indian tribe to be served.
Oh, wait, hang on a second. Okay, so this is defining the qualified applicant pool for those to seek self-governance.
Self-governance is
and then what does tribe to be served means? That doesn't mean that it has a tribal share, because there are a lot of tribes. I'm sorry, is it 25 or 50 tribes that receive services at this clinic? How do I know what to be served means? It doesn't mean.
It means
can't mean that.
It can't mean anyone who comes to the door, because obviously you don't know who's going to come through the door. What it is referring to is exactly what we've been talking about, which is
how do I know that's what to be served means?
Well, that's that. For example, if you look at 53, let me just double check that it does say this, unless I'm thinking of a different one.
It's just really confusing, the statute.
I know.
If there were like a nice direct provision that would say what you're saying, and the language just keeps changing. So I'm not how the definition of applicant pool, and there's no doubt that Fort McDermitt meets the qualifications to have sought not a self-governance compact.
So there it uses the phrase to be served. In 5304, it uses the phrase services benefiting more than one Indian tribe. That's 5304L. So Congress didn't use like the same phrases, but it means the same thing. It's not saying that every single potential Indian tribe that might be served at the clinic must provide.
So I had read this as thinking that Fort McDermitt has to have a formal resolution to seek self-governance. The tribe.
No, because
but it can't be to be served either. Right. There's so many being served in this situation.
Right. That's why that's referring to other tribes with a stake in the program.
How do I know that? That's what that's
well, for the reason that you're suggesting, which is it can't mean anybody who might possibly.
Well, it can't mean in this case, but I think this case is unusual. Usually, you don't have 50 tribes using another tribes.
That isn't unusual in every case.
Something in the record says is unusual in this case. Okay, I misunderstood. Okay.
IHS always requires that tribes provide healthcare to anyone.
Is there a legal? I'm sorry. Is there a legal requirement that any clinic, even if the clinic is dedicated to the local tribe, any a member of any tribe can go in and get services?
There might be. I know that IHS requires it, but I don't know off the top of my head whether that's in the statute.
Requires it in the funding contracts.
Right.
Okay.
Did Fort McDermitt request participation in a self-governance compact by resolution and admit that IHS is part of Interior?
I'm sorry.
Did they to get the ball rolling here on this whole process to take over the clinic? They must have had to request participation in a self-governance compact by resolution or other official actioning of their governing body.
I don't know whether the actual tribe that's requesting to take over does a resolution
Really?
as well.
Really, Interior is not going to be a tribal government? Of course they are. They do that.
I don't. What I'm trying to say is I don't know whether that's formally. It most likely is.
I think that's what
the point.
C1B says. They have to. This is talking about the tribe, the ones that are in the applicant pool. This is the one that's applying. This refers to the one that's applying, and you're going to make sure that the tribe has official resolution. I mean, you have to have official resolution.
So you're probably right on that point. So I'll just.
Right.
You're probably right on that point. But let me.
Doesn't help you at all. Okay.
No, it definitely does.
No, I think that means that's the tribe that's taking over, that's participating in the self-governance.
Well, so look at the 5304L and the proviso that was added there.
Let me try again. Slow down again. Okay.
Yeah.
5304L.
Mm-hmm.
Okay. All right.
If you look at the proviso at the end,
mm-hmm.
It says, provided that in any case where a contract is let or grant made to an organization to perform services benefiting more than one Indian tribe, the approval of each such Indian tribe shall be a prerequisite. So there, it's referring.
But that's not giving them that's not an approval to give over the share. That's just approval to have someone contract to provide their services.
That's right. And now, if you put that together with the severance provisions, that means McDermitt can't take over the program in its entirety because it's benefiting.
But Winnemucca didn't. Did anyone ask Winnemucca if it's okay? Not to get their tribal share, just do they mind getting services from? That's a different question. Are you okay if the services are provided by Fort McDermitt rather than Winnemucca? That's how I read this.
Well, so you're right, but you have to combine the provisions. So here's how it works. Fort McDermitt needs the consent of the Winnemucca to take it over under 5304L. That was a proviso Congress added after testimony about the fact that it would create lots of problems if tribes could take over programs that other tribes benefit from.
This is, again, services. This gets me back to my same question. What does it mean to be services benefiting more than one Indian tribe? So not just Fort McDermitt, like we were talking about under the applicant pool. So to perform services benefiting more than one Indian tribe, that means, how do we know benefiting them means taking your share as opposed to providing medical services to you?
So you have to read this in the context of IHS allocating funds to Indian tribes for decades. What it means is when a program is supposed to be serving more than one tribe, then a tribe can't take it over without, in its entirety, without the consent of the other. But then the severance provisions say that when a tribe take over something it can't completely take over, IHS has to approve the portion that it can take over. That's what IHS did here. You're requesting to take over a clinic that also serves Winnemucca. Winnemucca has not consented. Here's the portion you can take.
It's just the verbs that are confusing me. It's more than, it serves dozens of tribes. It serves anyone who walks in the door, or I guess anyone who's a tribal member, but.
Right, so this language is not referring to, you have to get the authorization of any tribe that might walk through the door, because that's impossible. What it's saying, it's referring to IHS's practice of allocating to the different tribes.
Okay, thank you.
Sure, thanks.
Very confusing, but thank you for walking me through it.
Thank you. We'll hear from the plaintiffs here, from the tribe. Ms. Patterson.
Thank you, and may it please the court. I'm Rebecca Patterson for the Fort McDermitt Paiute and Shoshone tribe. With all due respect, what government counsel just told you is filled with legal and factual inaccuracies. So I'm going to do my best to try to clear things up. First of all, there's been no long-standing formula or no decades of IHS providing services to the Winnemucca tribe through the Fort McDermitt Clinic. What there has been decades of is IHS serving the Winnemucca tribe through a purchased and referred care program, which means that IHS pays for Winnemucca tribal members to receive services at private, non-tribal providers, and they pay for that care. And this makes sense, and you need to understand a little bit about the geography of the region. Winnemucca is a city that is 20 times bigger than McDermitt. It has a hospital that serves the entire region. It has several private healthcare providers. McDermitt is a teeny tiny reservation that if you blink, you will miss it. I actually did. I was in Oregon when I first went out there. I had to turn back around. And it's an hour and a half from Winnemucca in the wrong direction, as in not towards Reno, the big city, but in the wrong direction on a road that is barely impassable in inclement weather. So it did not make sense for IHS to serve Winnemucca tribes through this small clinic an hour and a half in the wrong direction. It made sense for them, for the few people that needed services, to just pay for them to see private healthcare providers. What you have here is the SURE service unit that serves 13 tribes. IHS, in its discretion, decided how it was going to serve those tribes. Some tribes have clinics. Some, McDermitt, they actually call it a health station because it's fairly small, but the Walker River tribe has a clinic, the Pyramid Lake tribe has a clinic, the Reno Sparks tribe has a clinic. Some of these tribes have always just been served primarily by a purchase and referred care health program, such as the Winnemucca tribe. When a tribe comes into compact or contract, they get the funds for however IHS had determined to serve them. So when the McDermitt tribe comes into contract, they get all the resources that was going towards the clinic that's serving them. The Winnemucca tribe can still exercise their self-determination rights. When they come in, if they choose to contract, they would get the resources for the purchased and referred care program that IHS has always run for their benefit. Now, those resources are not in any of these tables on the record. Why? Because when Fort McDermitt was contracting, we only requested resources that were relevant to the Fort McDermitt program. We weren't asking about the money for Winnemucca. And government counsel even said that those funds are dealt with separately. There's a whole nother budget. There's a whole nother bucket of funding at the service unit that funds that purchase and referred care program. What happened here is that when the tribe came into contract, all of a sudden, IHS said, well, yeah, they've admitted we've been using those funds at the McDermitt Clinic for the benefit of—
Wait, you just broke up. Could you just repeat that sentence once more?
Sure.
Sorry, you just broke up. You said when the tribe came under contract. What was the rest of your sentence?
When the tribe came into contract here, IHS admitted that all these funds were being used at the Fort McDermitt Clinic. But then they said, we need to cut some of those funds off the top to allocate to Winnemucca. It doesn't matter, it's divorced from what they were actually doing. It's entirely a budgeting exercise. And that is contrary to the statute, which is very—
But as a budgeting exercise, do you dispute that those are funds that are budgeted for the Winnemucca tribe? The $190,000 was budgeted for the Winnemucca tribe's healthcare in some form or another?
I don't even think that's clear from the record. First of all, before 2013, this tribe—
Well, we have charts that say Winnemucca tribes share $190,000. So I don't know what else that would mean other than that those were funds that were budgeted. Maybe it was a bad allocation decision. I don't know why they have an extra $190,000 that they can, put in here for, even though they know, I guess they're doing the head count, but they know nobody's going to come down and use it. Why they don't reallocate it, but that's in their wheelhouse. But I didn't think there was any factual dispute that this $191,000 had been budgeted for health care for the Winnemucca tribal members. They just hadn't been using it.
Right. Well, the reason I say there's a factual dispute is because the 190,000 has been different numbers, but I agree.
Some number in that. There's some number.
There is some number
that dollars that you want that had been budgeted to Winnemucca tribes healthcare.
Correct. And our position is it doesn't matter how much they budgeted. It could be 190,000, it could be 500,000, it could be 300,000, because the budget doesn't matter. What matters are their actual expenditures. That's clear from the statute. That's clear from Congress, who, when they were amending the act, and they've come back to amend this act 3 times.
I don't think anything is clear in the statute. I'm sorry. It doesn't strike me as very clear at all.
Well, so Congress said one of the reasons they needed to amend the statute is because it was, quote unquote, hard to correlate projected budgets with actual expenditures. And courts that have looked at this issue have looked at 5325.
Where did Congress say that?
They said that in the 1987 Senate report. I think it's Senate Report 100-574.
I assume that's in your brief, right? I know you were talking about the reasons they did these amendments.
Yes.
Okay.
And I can find you the exact page site in a second.
That's okay. Listen, don't waste your time. But there's nothing in the statute that says that is our problem.
Well, the statute says you get what the secretary was no less, the statute says you get no less than what the secretary was otherwise providing. And every court that has looked at that has said that what that means is their actual expenditures. What were they spending at that clinic? You see that both in this circuit's cases in the Navajo Nation.
Well, they also says what were portions thereof. What does that mean?
That's because a tribe doesn't need to contract for every program. So in this instance, for example, Fort McDermitt could have come in and said, we want to take over only diabetes. And we want UIHS to keep running dental and medical and substance abuse programs. And so they can take over just that portion. They actually
portions of the program, not portions of the funding.
Right, portions of the program. It refers to the program's funding.
Isn't the answer to this question in the stipulation? The stipulation between the parties says that the $600,000 is what was spent. They were the actual 2015 expenditures. Is that what that number is?
Correct. That's where the tribe based its proposal off of, and that's at Joint Appendix 231, just for anyone else who's following.
Right, but this is a stipulation between the parties, correct?
Correct.
And so HHS agrees that during the year that determines the amount of money that the tribe will get under its contract is $600,000, right?
Mm-hmm. Sorry,
Am I right about that?
Sorry. Yes, that is.
I thought it was 555. Oh no, I'm a little confused on. I don't see 600,000 on page 231. I see
you don't see it there?
I see a projected expenditure of 603. Is that the number we're talking about?
Right. So just to clarify, the projected expenditure for 2016 was 603,842, which it was based on the actual FY 2015 expenditures, because at the time of negotiation, 15 was the
right.
year that we
okay.
had.
Okay.
What I just actually worded is
HHS. They agreed with this. This is their stipulation, right? Okay.
Do we have an actual number for 2016?
You have
there's so many charts here. I'm sorry.
Right. Well, that's part of the problem. The record here is a bit of a mess. But you do have the in 2018, the agency put together a whole new table of what they actually spent in 2016. That is at Joint Appendix, I believe, 221. And give me a second, I can double check that page. Joint Appendix 238. And that table shows that in 2016, they were spending nearly $1 million at the clinic. They also paid the full funding amount, the $502,000, to Pyramid Lake as a result of the Pyramid.
And that's not an issue in this case, right? We're only talking about the 600 in this case, correct?
Well, it's all somewhat at issue because the agency combined the two and said for both programs, you get 555. So if you put aside the EMS program, all they awarded the tribe was $53,000 to run the clinic, even though—
Sorry, I'm confused again. On 238, there's an awful lot of numbers, and I don't see, which paragraph are you talking about on 238? Did you say JA 238? Did I mishear you?
Excuse me, it's Joint Appendix 239 is the table.
Okay, all righty, good, sure. Okay, and this is what they actually spent in 2016?
Correct, according to the agency. This was put together after the fact.
Where's your number? Which number? Sorry, there's a
The number I was pointing to is in that bottom right corner. It's 982,663.14.
This is personnel compensation, travel, transportation, rent, communications and utilities, contractual services, supplies and material, equipment.
Right,
That can't be the clinic. There has to be medical care. There's no medical care on this list. There's no salaries on this list. I don't understand what this list is. I guess personnel compensation, is that all the salaries?
Correct. And if you look at the grand total, that's what they were spending at the clinic. They were also spending the $502,000 on the EMS program. So their own data suggests they were actually spending $1.5 million that year. We are only asking for 1.1 here. But I will also add that this is part of the problem, because the statute is very clear on the agency's burden here. The agency has a burden to clearly demonstrate their specific findings for declining the letter, not with tables that they added 2 years after the fact, but within the 45-day statutory window. The government had a burden here and they simply did not meet it.
So can I just, again, I'm just kind of so confusing, because you have that chart and then you have on 236, you have for FY 2017, you have 686,000. And then there's another FY 27 for hospitals and clinics, which I thought is the category at issue here. And then you have on 234, another one that says FY 2017 hospitals and clinics, 555,000. So it just feels like there's numbers all over the place. And so I don't know whether it's 900 or 600 or 500.
And that was the agency's burden to explain that. And they clearly did not do that here.
Well, it was also your burden to say how much don't you have to show that you're asking for, your argument here is you were asking for what they were spending.
Right. And
which
as it's stipulated,
which of these numbers is what you were asking for that they were spending? I thought it was more like the 600,000, then you add up the 500,000 from EMS, and that's how you got to your 1.1 number or something like that.
Exactly. So
you're not asking for this 980 something that you just talked to us about.
No, the tribe was basing off of the data they were provided at the time. All of these charts were provided after. Later. So at the data provided at the time, the last full year of data we had was for FY15. The chart produced by the agency, which is Appendix 110, said, we're projecting expenditures of 603 because that's what we spent for FY15. So we said, okay, that's our last year of expenditures. We'll add the 603, and then we added the EMS amount. That's how you got to the 1.1. And that was agreed to by stipulation, again, in that joint appendix, page 231, paragraph 12.
Is it right, by the way, that they haven't been giving you the money from the injunction? Because
that's correct. They actually haven't even added the employee housing services provision in the first summary judgment below that the agency is no longer appealing.
Did they issue an amended funding agreement by December 1st, 2016?
They didn't.
The order specifically orders that.
They have not done so.
You haven't gone back to the district court and said, okay, well, that's your choice, I guess. Okay. I'm surprised.
I want to follow up. I want to follow up what you said about the rejection letter. You said they didn't make their case in the rejection letter. I asked Mr. DeSantos that question specifically, and he referred to a couple of sentences in the letter. What's your response to his response to my question?
Those couple sentences in the letter, again, were on Joint Appendix 123, just says it just reflects shares allocable to Winnemucca, but it doesn't. That's the same budgeting argument, the same argument they raised in Pyramid Lake, the same argument.
Say again, what does it show that it should under the statute?
It should show.
You say it's the amount they budgeted. What should it show for them to have properly raised this issue in the rejection letter?
It should show that they're actually expending these funds for services for the benefit of the Winnemucca tribe. And the record does.
You mean in the previous? In the last year?
In the last year, even in the last 3 years.
And so the language, I don't have the language in front of me. The language he cited is just budgeting. It's not actual expenditures. Is that your point?
Yes.
They also make their argument about you're taking shares allocable to Winnemucca in that same paragraph. That's their whole argument. And you exceed the tribe's applicable share of IHS programs. The table shows you are taking shares belonging to other tribes. Your number, it also reflects shares allocable to Winnemucca. So I don't understand your argument that they didn't raise this point.
I'm not contesting that they didn't make their budgeting point. We just think that
well, they're also making their shares. You're taking tribal shares. They make that argument too. And the statute forbids that.
Right, but that's not at all supported by the record that Winnemucca has any shares in the McDermitt clinic. And that's what they don't explain. How does a clinic that is not serving Winnemucca, when you have a tribe that is served by an entirely separate purchased and referred care program, how does that mean that you then are also serving them through this clinic, which you're still not doing? In the divisibility provisions that Mr. Dos Santos was citing to, what you actually see is IHS actually providing services in that facility and continuing to do so. So for example, in another service unit of the IHS that served 3 tribes, 2 tribes wanted a contract and 1 did not. So IHS literally had to redesign, and those 2 tribes contract in 2 floors of their building, and the 3rd floor, IHS is still there providing services to the 3rd tribe. That's what it looks like when you have a program benefiting multiple tribes. In this case, if this really was benefiting Winnemucca, when the tribe came into contract.
Was summary judgment inappropriate here because the facts are just a wreck? We don't know amounts. You're disputing whether there actually were or were not allocable shares.
Summary judgment was appropriate because the agency has a burden to meet and they did not meet it. The parties do not disagree on, we had a spreadsheet that said this number or a spreadsheet that said that number or what. The parties actually stipulated to facts of what was in front of the court. But the agency has to make specific findings. And the reason that the court is struggling is because the record is a mess. They did not make specific findings here. They did not clearly demonstrate why their chosen ground for rejection. And it has to be one of the
What more were they supposed to say when they say this reflects shares allocable to Winnemucca? The tribe's share was, they have the 190,197. What more are they supposed to do?
They're supposed to explain that the McDermitt Clinic is providing services for the benefit of Winnemucca tribe, and not just a funding share, not just a budget, but what services are they providing there for the Winnemucca tribe that the McDermitt tribe
But you don't dispute that Winnemucca tribal members were getting services here. Not many, but that they were. I didn't think you disputed that.
We do not dispute that 2 Winnemucca tribal members receive services.
All right,
but that's
so you knew what services they're getting.
Only pursuant to the open door policy. So that doesn't convert this, I think even Mr. Dos Santos agrees that just because a tribal member from a neighboring tribe walks in the door, that doesn't mean that the clinic is.
But then it seems like it's not that they didn't say it here. They did say it here, and you're just disputing. You say it's just false. You never allocated shares for Winnemucca. That seems to be your argument. They said, it's not that they didn't explain themselves. They said, we have allocated shares in the amount of $190,000 blah, blah, dollars for Winnemucca tribe. You're not allowed under the statute to take that. They've said that. And so you're seeking more than you're allowed. They said that. And you just say, it's just not true.
Correct. That is our position.
Sounds like a fact. Okay, well, that's not the problem of their letter being insufficient. That sounds like a factual dispute.
Well, they have to.
How are we supposed to resolve that?
You're not resolving the factual dispute. What you're actually reviewing is, did the agency, did the IHS clearly demonstrate these specific facts that they're putting at issue here? Did they clearly?
They've got it there in document, and your answer is untrue. And I don't know what, I don't know what we're supposed to do. That's just sort of almost like a credibility thing. It's just, you're just not stating the truth. It's not that you didn't say enough. It's that it's false. And I don't know what more how they were on notice that you were going to call their credibility into contention here.
Well, they were on notice, well, for a number of reasons. They did mention their tribal shares argument, which we think I'll call it an allocation argument. So they did mention that. I agree with you. And we think that that is legally incorrect. We think that is false. But what they also
wait, legally incorrect and false are not the same thing. How is it legally incorrect?
We think both, because we think the statute says it's not your budget, it's not your internal allocation that matters. When a tribe comes into
yes, but the statute also says an awful lot about not taking other tribes' shares, and it makes sense as a sort of concept of self-determination. So you can't just look at one statutory provision, you got to read it as a whole. So,
right.
So that doesn't, just pointing to one section doesn't tell me why they're legally wrong on the sections they cite.
The provisions they're citing, though, do not apply here. When we're talking about a tribal organization, which is what Mr. Dos Santos was referring to in 5304L, that's when a tribe designates another organization to contract on its behalf. It was relevant for the EMS program when the Fort McDermitt tribe said, we're going to authorize Pyramid Lake to contract for that program. If Fort McDermitt tribe had come in and said, we're going to authorize the Fort McDermitt Healthcare Corporation LLC to contract, that's where that definition.
Why does it have to be an outside tribe? Why couldn't it also be, this was a program that Interior was running to provide healthcare services to two tribes, and now one wants to take it over. What in those statutory provisions says that the requirement of consent to take over the allocable share, tribal share of another tribe is not required? Where in the statute says that in this circumstance instead of the third party one you're talking about?
Right. So just let's be clear. When we're talking, you have to look at what is actually happening. Is IHS providing this for the benefit of multiple tribes? So if let me give you the example that would apply in. If Fort McDermitt had come in and said, we want to contract for our clinic, and we want to contract for the PRC program serving Winnemucca, then they come in.
They said we want to contract for this clinic, and
right.
IHS says, okay, thank you very much. This clinic is a two-tribe clinic.
But it's not a two-tribe clinic. It never was
That's your factual dispute. Okay. All right.
Right. So that's
right. It's a factual dispute. Okay.
Yes, it's our factual dispute.
All
but
right.
we also think that on the law that they have to provide what the secretary was providing for Fort McDermitt. And so therefore what they were budgeting doesn't matter. You have to look at what they were expending, and that's the legal.
And what is that number? What is that number?
The amount that they were expending?
Is that the 600? That's the 600?
The 600 plus the 500,000 for the EMS program. So it's 1.1 million total.
Okay. All right, great. Any other questions, Judge Millett or Judge Katsas? Okay. Thank you, Ms. Patterson. Mr. DeSantis, you were way over time, but you can have 2 minutes.
Thank you. I'll just briefly state.
You don't have to take all.
Well, I have a question after you said something. Just one more question. Go ahead.
I was just going to say that it seems like the issue has been clarified to the extent that there's it's clear that IHS said it was budgeting an amount for the Winnemucca here, and then plaintiffs raise a factual dispute about whether or not that means it's a multi-tribe program and so forth. But
is that the same as actual expenditure? Is that the same?
I'm not sure what you mean, Your Honor.
Doesn't the statute I'm looking for the provision of the statute. Doesn't the statute says that under the contract, they get the amount that was expended in the previous year?
It does not. The statute says the tribe gets the amount of money that the appropriate secretary would have otherwise provided for the operation of the program.
Doesn't provided mean, what does provided mean?
So provided means what the secretary was prospectively going to allocate in appropriated funds to the program.
For the program, not for the tribe.
For the program.
To the program, right. The tribe may, in fact, only be able to take over a portion because it's not authorized to take over the whole. And then it would give the tribe its portion, its tribal share.
Who made the decision? Who made the decision to allocate tribal shares for Winnemucca tribe to this clinic? Was that done in consultation with Winnemucca tribe or just by Interior itself?
IHS made the decision without consultation
Okay,
because the Winnemucca tribe didn't have a government.
Okay. All right. And when did it make that decision?
In 2013, which you could see the letter in JA 1 to 24, it has, the initial letter saying, we've consulted with tribes in the region, Winnemucca accepted because they didn't have a government. And we've allocated tribal shares for the shared service unit. Here are tables showing what each tribe is getting. So my understanding is that that was the most recent round of consultation and allocation.
What's the relationship between the money that you say was allocated to the Winnemucca as a budgeting matter for their tribal share and the money that was actually spent to provide healthcare to the Winnemucca through this separate purchasing program? Is that part of the allocated share, or is that something completely different?
It's something completely different.
When you're allocating
their own.
So when you're doing the allocation of shares, someone at IHS says, we think the Winnemucca should have such and such amount allocated to them, but taking into account that most of their members are getting care through some separate bucket of funds.
So IHS, you could see this in the tables in the 2013 consultation from JA 1 to 24. IHS was allocating based on what it called active users, which is number of potential users of healthcare services within the area that's assigned to a particular tribe. And it did that for all of the tribes on the same basis, came up with a number, and then assigned those to programs.
Where is the assignment of this share to the clinic in this letter or these charts? As opposed to, I get they get this much money, but where are they assigning it to the clinic, the Fort McDermitt clinic?
I believe.
Because you had to hold some of it. You had to hold a lot of it back for their PRC, right?
No. PRC is a separate pool of funding.
Okay. All righty. Okay. Really? Okay.
Okay.
Yeah, I don't have a site for you for your question.
All right.
I'm just trying to get the site.
Thank
here.
you.
You don't have the site right
sorry.
now? Sorry, do you have the site?
No.
If you get a site that says when you dedicated that to the Fort McDermitt clinic, it would be very helpful to have that. If that was maybe it was part of this 2013 letter.
Okay.
Anything else, Judge Millett? Judge Katsas? Okay, thank you, Mr. DeSanto. Thank you both. The case submitted.
Thank you.
This honorable court is now adjourned until Monday, October 19th at 9:30 a.m.